Ryan C. Cheatham versus the Kansas Department of Corrections. Elizabeth Fowler appears representing the Department of Corrections. Joshua Andrews appears representing the petitioning inmate in this case. All right. Again, Ryan Cheatham appears as the petitioning inmate, separately from his lawyer by Zoom. This matter comes before the court at this time for further proceedings. There was an earlier proceeding in the case where the court recessed to allow the attorneys to research an issue that arose regarding a possible liberty interest suffered by the inmate in this case for alleged loss of accrued good time credit. The court has looked at the file, and it doesn't appear that there was any documents that verified that he lost accrued good time credit. But I'll ask Ms. Fowler, did your research or further checking indicate that he did suffer that penalty?
Your Honor, as I filed with the court and made available to my opposing counsel, I filed what was marked as Exhibit H, which is good time award record for Mr. Cheatham for the time period in question. There were 4 DRs that Mr. Cheatham received convictions for during that relevant time period, including the DR which he appeals, the battery DR. The document reflects that he had good time withheld. So he did not earn any good time for that period in question, but that no good time was forfeited. And I did provide that to opposing counsel shortly after our last hearing.
Your Honor, may I address the court real quick before we proceed?
Just a moment.
Because
okay, go ahead. Go ahead.
I'm choosing because I was on mute, but I'm choosing to invoke my right to represent myself because, like I said, I'm not a lawyer, but I, you know what I'm saying, comprehend the law, I feel like a little bit good. And the liberty interest that I feel like is at hand, it refers to the Wolff versus McDonnell, and it's about the due process procedures in a disciplinary hearing, the impartialness of the hearing. Also, you know what I'm saying, I would like to address the good time credit too that she's talking about, because the document it's extrinsic. It's an extrinsic piece of evidence, and I feel like I got another form that shows 133 days available versus 0 days, and then the document that they provided to the court states 23 days. You know what I mean? So and I've read a case law that says that we can't challenge the fact that with unearned good time is not a liberty interest. Good time that's withheld is not a liberty interest because one hasn't earned it yet. Well, I feel like the document, you know what I'm saying, I feel like we need to have an evidentiary hearing or be able to prove like or direct the courts to direct KDOC to show the good time that I did have in the bank that was available, and whether or not it was subtracted, the 23 days was subtracted from that, because I feel like that document that was provided only shows the 23 days that were available, and it's saying that, you know what I'm saying, I feel like it's not, it's ambiguous and it's vague, sir, you know. And I also want to address the fact that there was insufficient evidence to convict.
Okay, Mr. Cheatham,
Yeah.
I'm just going to put a hold on things for a
Okay,
moment.
go ahead.
I was going to address your attorney regarding the liberty interest regarding accrued good time credit. Mr. Andrews, did you have any additional remarks to add to Ms. Fowler's?
Your Honor, in light of my client, he had let me know before court that he was desiring to represent himself going forward. So I was going to ask the court to, I think he has the right to represent himself on these proceedings. I was going to ask the court to allow him to represent himself going forward and propose that I remain on the hearing as standby counsel, but that regarding any substantive comments on the issue that Mr. Cheatham's requesting to represent himself on that.
All right. And given that statement, Mr. Cheatham, are you indeed wanting no assistance from legal counsel in this case, and instead you want to represent yourself in this disciplinary hearing matter?
I mean, it's like I feel like my argument, you know what I'm saying, with the liberty interest is being swayed.
That's a yes or a no, really.
Yeah. I'm wishing to invoke my right to represent myself. Yes, sir.
All right. Stay on the meeting, muted. Mr. Andrews as standby counsel. All right. Mr. Cheatham, you're trying to cover a lot of ground really, really quickly. I'm going to go back to Ms. Fowler for a moment. He seems to suggest that somehow the records don't reflect that he didn't lose accrued good time credit. Do your
Well, Your
records
Honor,
show what he had earned as of the date of the offense in this case?
Your Honor, I don't have a accounting of all of his hours, but before we even get to that, Your Honor, I would say first of all, his petition in this instance didn't mention good time at all. This is an issue that came up later after he reviewed my brief in which I said he had no liberty or property interest. And then he's since then inserted this good time argument. I don't think that's proper, but I did accommodate, provided the record. Now he's asking for additional records, but Your Honor, the burden is his. It's not mine to prove that we didn't take any of his good time. He didn't assert it in his petition. I've produced what we have related to the good time record for that time period. He hasn't asserted any property or liberty interest that would invoke his right to those due process protections as he's indicated that he was denied during this hearing.
I did state that I wasn't able to call witnesses, and I also stated that I was never afforded the appeal or whatever as far as on remand of the record, the clarification of the record. So I did state liberty interest, and I'm looking at Wolff versus McDonald's, and it says that I have a right to prepare a defense. I have a right to call witnesses on my behalf, and I wasn't afforded that opportunity to do that.
And Your Honor, the case law is that he has to prove that he had a liberty or property interest.
Right.
And
So the
he
liberty.
didn't-
Okay,
the
Cheatham, hang on
liberty-
just a second.
Go ahead. Yes,
I
sir.
do want to refer to the Secretary of Corrections ruling in this case as part of the exhaustion of administrative remedies. The sanctions that are referred to on the back of that document indicates 15 days disciplinary segregation. And
Right.
that's
So the issue was, remember, I said that I lost good time that the unit team took. The disciplinary the disciplinary hearing officer didn't take good time, but the unit teams did. So that's why we recessed so that we would be able to provide to the courts the documentation of where I lost good time at. So the good time, the exhibit that Ms. Fowler submitted to the courts, I'm saying that it's vague and ambiguous, sir, because it doesn't show. And it doesn't show what I lost in the bank. It doesn't show. It only shows a summary of something. And in my opinion, in my position, it's extrinsic. We shouldn't rely on that. We should
well,
either
then
have
what
an
should we
evidence.
rely on?
I
Your
would rely
wisdom?
on no, absolutely not, sir. I would rely on either evidence we're hearing so that the unit teams can testify to exactly what was lost of good time. But to rely on a paper that I have that's contrary to her document, one says 23 days, my document says 133 days. So which one do we go with? Which one, you know what I'm saying, is proper?
Did you even raise this claim in your petition?
I
for
mean,
habeas corpus relief?
but you chose to entertain it though. We recessed to entertain it, and now I want to further entertain it, but I also want to address the fact that I wasn't given a fair partial hearing.
Okay.
I mean, I just want to make sure that that all the rights are afforded to me, because like I said, according to Wolff, it's saying that, you know, that we're entitled to a impartial hearing, and my hearing wasn't impartial because I didn't swear in and raise my. So not only was I able not to provide a defense, which it says I'm allowed to, and if staff assistance was appointed, I was supposed to be able to direct and guide that staff assistance, which I didn't. And then the sufficiency of the evidence, you know what I'm saying, that how they convicted me, it was you know what I mean, a short statement. An adequate statement of reason must be based, point out the essential facts upon interference were based. You know what I'm saying? And it was the record, due to the preponderance of evidence, it was found guilty. But Secretary of Corrections remanded it for clarification of the record because they wanted to know specifically by the reporting officer whether or not I made physical contact in an assaulting manner. and this decision to uphold wasn't until 9 months later. And I wasn't a part of that second process, which I also have a right to be present at every stage of the disciplinary hearing. So, you know what I'm saying? So for us to just focus on the good time, I feel like is an attempt to sway an argument that we already know is going to get denied anyway. So that's why I chose to represent myself, because like I said, I don't want to get taken advantage of, because I don't have the degree as Mr. Andrews. So if I'm wrong about what I'm saying, you know, you can let me know, and I guess my remedy would be to appeal.
All right. Mr. Cheatham, I don't have any record in this entire file that indicates that you lost already earned good time credit.
Right.
The Department of Corrections record should reflect if that was part of this disciplinary proceeding or not. And clearly, it indicates that the sanction that was imposed is 15 days of disciplinary segregation only. So I think Ms. Fowler's point is well taken. There
Right,
was no
so,
loss
okay,
of a
can I-
property
can I-
interest or a liberty
can I-
interest under those circumstances. What you can not do is interrupt me when I'm talking.
Right, but you knew that our last court date, sir. So why would you recess it for us to be able to provide further documentation? And when her documentation provided to the court is vague, now you want to go back to the DR initial that I received 15 days disseg to substantiate and deny my petition. So basically, you're not going to afford me an opportunity to combat her document, is what you're saying. So why did we recess it in the first place?
To have her look into it further, which he has
Right.
done.
And I got a document that contradicts her document, and I'm trying to provide that to the courts. So how are we gonna go about that? Her document doesn't show 133 days.
And it shows as
Bad.
part of your disciplinary proceeding that you incurred a loss of accrued good time credit. Is that what your document shows?
Yes, sir. It shows that there was more good time available other than 23 days. So what I'm saying is the documents that we
Mr.
should
Cheatham,
either have.
let me ask you this.
Go
Let me
ahead, go
ask you
ahead,
this.
sir.
You've
Go ahead.
had
No, can
multiple
we-
disciplinary proceedings, haven't you? Are you sure that
Can
if
you
there
give
was an
me-
adjustment of your good time credit, it wasn't connected with one of these other disciplinary cases?
No, I'm saying exactly that. I'm saying I want to have an evidentiary, sir, so that we can have the unit team managers come and provide either testimony or further documents. Because I can send this over to the courts. I don't know if you can see this right now, but the document that you're looking at, it shows hold on.
Okay, I really can't see it. It's just all blurry.
Okay, you see where it says hold on, why it's being blurred out. Why is it? You see that word? Yes. Are you blurring it out or what? Well,
Ms.
it says
Fowler, are you
100.
familiar
Okay,
with this
so
document he's holding up?
it's the same one, sir, that she has, and it shows 23 days versus mine says 133 days. So my argument would be that this is an extrinsic document, and we have to further investigate the actual good time that was taken from me, because this paper shows the 23 days outside the Senate bill. It shows more than 23 days. You see what I'm saying? Like the
No, I
document,
really don't.
the document that's in front of you, sir, it shows available good time credits for award period. It says 23 days. My document says 133 days. And then it says good time credits awarded. It says 133 days. So what I'm trying to say is this paper that we're relying on to see what was available and what was not, what was forfeited and what was not, and what was withheld and what was not, to establish a liberty interest is vague and ambiguous. And I'm asking the court to allow an evidentiary hearing so that the unit teams may present further evidence. And I feel like I deserve that
To
because
allow that, Mr. Cheatham, I would have to be convinced that the records from the Department of Corrections are incorrect, that you actually sustained the loss of accrued good time credits as a part of this disciplinary conviction. This is not a proceeding to determine what good time credits you're entitled to as a prison inmate.
Right, I'm not saying that,
Generally
sir.
speaking.
I agree exactly what you're saying. I know what you're trying to say, and I just want the opportunity to show that I lost good time. I lost 23 days of good time. And I
We
want
had
to, 23
days withheld, Your Honor. He had them withheld. They weren't forfeited. He didn't earn them.
so let me just say this real quick. The unit teams can only take good time you've already earned. They can't take good time that's not in the bank. The disciplinary action can take up more than 6 months, but the unit team is only allowed to take what you have already in the bank, Your Honor. So that's what I want to be able to cross-examine and to have the unit teams testify to. So let's just say this: if you pay me for working for you, sir, and I got money in the bank from working for you, right? So the unit team is able to take from that money that exists in the bank. They're not able to take away from next month's paycheck. You know what I mean? So that's what I want to establish, that I lost good time that I had in the bank, not future good time.
All right. I don't have the document before me that Ms. Fowler has. I don't at the moment. When was your additional
Honor.
exhibit submitted to the court?
It was filed into the record yesterday, exhibits H and I.
All right.
And if I should do that differently next time, Your Honor, I wasn't sure how best to provide those documents. And like I said, I did provide those to opposing counsel, and I did provide our good time record shortly after our last hearing. And I didn't receive any additional documentation from Mr. Cheatham.
All right. I believe
notified
those
you.
exhibits are pertinent to our discussion, so I'm going to recess briefly and access those two exhibits.
Sir, this exhibit I found yesterday, and I tried when Mr. Andrews
The court
came
will
with the-
recess briefly.
Yeah. You know it. I done beat 3 trials last 7 years doing what I'm doing. Hey, Crawford.
This time the court will resume the record in the Cheatham versus KDOC matter. All persons appearing as before, the court has now had an opportunity to review the very recently filed documents, Exhibit H and Exhibit I. All right, Mr. Cheatham, you're muted.
There you go. All right. Can you hear me?
Yes, I have before me a good time award record from Larded State Correctional Facility. The award date is stated at 12/11/2024 up in the corner. Is that the document you have?
No, sir. The document I have says the same similar good time award credit. And then it says from a period of 2024 through 2022, and it says 133 instead of 24.
Okay, this is dealing only with the award period from August 18, 2024 to December 18 of 2024, which was apparently while this disciplinary matter was pending.
Right.
Yours is apparently for the period before that.
Okay, so right, I get that part, right? But it's saying that so I guess according to the Senate bill, it says that because of my crime, I'm only allowed either 21 days or 23 days per period. But it's like that only shows, it doesn't show what was taken out of that bank, that what my argument is, sir. I'm saying, from my understanding, I just asked my unit team this question. I said, is it not my, because if I'm wrong, sir, I'm wrong. I'll kick rocks, you know what I'm saying? But what I'm saying is the good time that I've already earned that was in the bank, I'm trying to figure out how can we show that it was deducted from that, because that paper just shows the 23 days in you know what I'm saying, what was withheld and this and that. My other argument, you know what I mean, I don't know if you're going to entertain it or not, because this is why I chose to represent myself, because me and Mr. Andrews was kind of at odds with it. It's like, I feel like the Supreme Court, you know, and I'm not asking you to overthrow them, and I know you're not going to. So my thing is, our Casper website pages show an early projected release date, and it shows a later projected release date. So like, according to Casper, we already earned the good time. We already got it. We just have to demonstrate good behavior. And if we don't, it chips away and it goes to the later. It doesn't go from the later to earning the good time to the earliest possible. So I feel like, okay, from a business aspect, if the bank account has money in there, And you know what I'm saying, on paper it says, hey, Mr. Cheatham's already got this money in the bank because he's already earned his good time. All he has to do is show up to work. And if he works, then the books are cleared. You know what I'm saying? So it's like, I'm not trying to overthrow the Supreme Court, but that's why I didn't want to focus on that. And I'm like, well, hey, how do we not know from what the unit team managers is telling me? They're saying I can only take away what you earned. I can't take away what you didn't earn. You know what I'm saying? So that's why I'm like, why should we only rely on the good time paper when we can have these unit team officers come and testify as to their duties and how they go about deducting good time?
So I should rely on your hearsay statements regarding stuff that you say have been told to you by unit team members rather than the actual documents that the Department of Corrections maintains?
No, sir, I'm not asking you to
Well,
rely on,
okay.
I'm not asking you to
All
rely
right,
on
I think I'm
hearsay
prepared to
because
rule. Mr. Cheatham, the documentation that's been provided by Ms. Fowler at the suggestion of the court indicates that you did have good time credits withheld during this pending disciplinary matter of 23 days. It clearly shows that you were not awarded those 23 days that you might have earned, but for the disciplinary conviction. But it doesn't show in any way, nor is there anything in this entire thick file that would indicate that as part of your disciplinary sanctions, you received a loss of accrued good time credits. In fact, the Department of Corrections has demonstrated to the court documents which indicate the concern the court had the last time we were in court.
okay,
I think
so
they've
that's so
shown that
so
you lost non-earned credits. You
all right,
didn't lose earned credits.
I will not dispute that. So is that the only liberty interest that I can argue, or is that what about the
That's the
witness?
only one that has been suggested to the court, Mr.
Okay,
Cheatham. And in
exactly,
fact, I'm not even sure you
exactly.
raised that issue in your petition.
Right. So now we're getting somewhere. So now this is why I said for us to argue that, and I didn't argue it. It was only meant to deny my petition. That's why I was opposed to arguing in the first place.
All
What
right.
I did argue in my petition and cited was the fact that I wasn't afforded to call witnesses, sir.
But you only reach those hearing defects, according to you, if you can show that there was a legitimate property or liberty interest triggered.
So the liberty
You did
interest
not get fined. You did not lose any financial matters at all. So there was no property interest triggered here. And the liberty interest would have been theoretically from the loss of accrued good time credits, which I think the Department of Corrections has shown didn't happen here. In fact, numerous documents would seem to indicate otherwise. So the court's going to find that we're not going to reach the issues of due process as there was no legitimate property or liberty interest triggered by the disciplinary sanctions imposed in this case. I'll also just note for the record that there appears to have been some evidence to support the hearing officer's
some
decision. And
what
that's a relatively low standard, and it was certainly met in the view of the
right.
court upon review
How
of the file.
can we elaborate on that, or we just
No,
right,
no,
exactly.
that's
So
just an observation that the court has made.
that's yeah. What observation? Just like you said that
So
you observed her
right.
document, then you recessed it to get it. Come on, man. All right. So
Mr.
what we're
Cheatham, I'm going to find in this case that the disciplinary sanctions in this case did not involve a protected liberty or property interest in this case.
now, and I want to
Therefore,
put this on.
the
I just
claim
want to
for
put this
habeas
on.
corpus
It's denied.
should not be furthered. And the
Right. And
court
I
will
just
not
want to
reach
put this
the
on
issue
record
of
for appealing
defects.
purposes. I did not argue the fact that good time credit was forfeited. This was erroneously projected to the court and presented to the court only to deny my petition, as stated by Judge and Ms. Fowler, that it was not even cited in my petition. So
Right.
so why
You
would we
didn't raise
argue
the
that?
issue of a protected liberty interest even in your petition, Mr.
But why
Cheatham.
would
You
you
argue it
entertain it
now
though?
so that the court.
I didn't argue that. That's what Mr. Andrews wanted to
Okay.
argue.
All right.
All right, y'all have a good day, man. God bless, man.
Okay. The writ is dissolved and the habeas corpus petition in this case will not be furthered and the case is terminated at this time. At this time, the court is in recess and the court will end the meeting for all.